The first question that I had is, has the board considered spot zoning, and is the board prepared to defend the law? I don't know what the board is prepared to defend, but I can certainly speak to the spot zoning. The information that was given was almost correct. It is zoning that zones a piece of land different than the land that is around it, and is not in accordance with the comprehensive plan. That is the part that was sort of fudged in the statement that was made. This is not spot zoning for obvious reasons. If there has ever been a community that vocalized its planning thoughts about a site, this is it. I mean, my God, you don't have to go very far to look at the history of this. It has been years in the making, with charrettes, and then just to put icing on the cake and dot the I's, cross the T's, put a cherry on top. You have a 2-page bullet point list that was prepared not by us, but by the village's independent planning consultant to indicate all of the ways it is consistent with a comprehensive plan. Now, let me just get away from the legalities for a moment and drive home one point. When you have a site that is special in some way, it has a big old building that's been there for 20 years, and it demands a comprehensive plan for its future development, that is precisely the type of site that you zone specially and that you create a special plan for. And that's why this was done. So no, it is not spot zoning, and hopefully no one will choose to bring what would be a meritless claim and force the village to spend tax dollars to defend it. The next question that I had was, does the B4A zoning exist anywhere else? And I believe the answer to that is no. This would be the first and only B4A district in the community. How does this compare to the Chestnut Ridge footprint? And I think, Matt, I don't want to put you on the spot, but I thought you had looked at this at one point.
Yes, approximately a month ago, one of the meetings, we did an analysis. I don't have the analysis with me, but it was suggested that all Chestnut could fit into buildings 4, 5, and 6, and that was proven not to be the case. My only suggestion for the moment is if you go out and take a look at the mass model, you'll see that we're pretty close.
Next one is, what is the status of the planning board's recommendations? The planning board's recommendations were considered by the village board individually. I believe there were multiple meetings at which every single planning board recommendation was discussed, and then some of them were discussed at quite a bit of length. Not all were taken, some were not, but I wouldn't want to bore you to tears right now of trying to go through all of them, and I couldn't do that from my memory anyway, but there was an extensive discussion.
Excuse me, could you just move to the living room floor?
Of course, absolutely. I just don't want to. How about if I'm standing right next to you?
Either way.
That's fine.
I
I'll
know
do that.
the
No problem. Make it easier. No problem. What will happen to the Leahy Pavilion was my next question, and I don't believe anything is going to happen to the Leahy Pavilion in terms of its uses changing. Next question that I had was, will the village green go away if there is no rezoning? And the answer to that is it could. I can't say what would happen definitely, but you certainly have a layout of what would be allowed under the applicable zoning. What else? Next question I have is, what can anyone else? Oh, that's rhetorical. I'm sorry. That was one. I don't want to repeat one of the comments that was made. Next question that I had was there discussion about a conservation easement for Gateway Park? Answer, yes, there was, and we have not yet fully discussed and worked through with the village's attorneys and and other professionals exactly the form that it will take, but certainly it was discussed, and it is a possible way of protecting that site. It also can be protected by site plan approval conditions, restrictive declarations. There's a variety of ways of doing it. Question of what does the height increase do to the view shed? Will ridge lines be obscured? Now, I don't believe that there was any technical analysis of this done, but I venture to say that if I know the person who was the source of the height increase recommendation on the planning board, there would be no impact on the ridge lines. I don't think we're talking about, in seriousness, enough of a height increase to affect anybody's view of ridge lines. It's just not that large of a differential. The renderings in the EAF compared to what is presented. Ann, can I put you on the spot to speak to that?
Sure, both the architecturals are still being developed, and the ones that were in the EAF were an earlier version, and they are simply representative. The ones that are up on the wall here that are also posted on the Butterfield website are a little more current, they're a little more accurate, but in both instances, they are still conceptual and simply representative, showing the applicant's commitment to designing something that's in keeping with the village architecture, but the absolute final details have yet to be worked out.
Okay. Next question I had was, is the senior center guaranteed or isn't it guaranteed? And I don't remember exactly who said it, but I think it was Mike Arenos who said it, that the county can't commit to something that has not yet been built. Well, that's obviously true. Mr. Gallardo is committed to building the building and having the space available. I think that has been out in the public domain now for I don't know how many years. It has never changed. We don't control what the county does or doesn't do. And I understand that there has been a commitment which was referred to by the woman who was the head of the county or town aging department, indicating that there is money available for the fit out, and the county has committed to operating it. I don't know what more can be said other than that. That's as much as can be done at this point, that Mr. Gallardo is committed to making it available to the county. Jim Cronin asks rhetorical questions. I'm not quite sure whether they... John, did I say Jim? I'm sorry. John asks rhetorical questions, but I'll answer them anyway. What are the reasons for saying no? And the implication being that if you don't say yes, you're somehow doing something anti-seniors. Look, let's be fair and honest. The village board is being asked to adopt a rezoning. It has its full legislative discretion. It can say no to a rezoning for virtually any reason. And I don't know that I would want to speculate about what the rights of seniors would be in that regard. The merits of this project stand on their own, and I think that the village board should make a decision on that basis, not out of fear that if they do say yes or no, that there's some claim that's lurking out there. Mike asked the question of what is as of right. As of right means a couple of different things in different places, but in this context, as of right means uses that are allowed without either a variance or a special permit from the village. So they are uses that are listed as permitted uses in the village zoning. They still require site plan approval if they are not single-family homes, but for purposes of evaluating their uses, they are what is listed as permitted in the zoning district. Now there were a couple of things that were not questions, but I would like to address them since I'll follow up on John's statement and that say that when I've been quoted, I can at least respond. So Matt made certain references to things that I said at an informational meeting or at a meeting before the village board, and I did say that the ship has sailed. The point that I was making was that the environmental review ship has sailed. Now, a lot of comments that have been brought up tonight speak to the financial analysis. That financial analysis was part of the environmental review. There were many, many meetings by the planning board. They were wide open to anybody to attend. Anybody could have come forward with all of the financial information that has been brought forward since then. I don't know why nobody did, but they didn't. And there was an independent analysis. There was a planning consultant and a person who was highly qualified, does environmental review all the time, and did subject us to an independent analysis, and that's the village's planning consultant. The fact of the matter is that I've been at this for decades, and I got to tell you, I'm baffled. And anybody can you can posit numbers and pull them out of this place or that place, but I can only tell you one thing. I have yet to see a single project that combines senior housing and commercial space that is not tax positive. I've never seen one anywhere. Now you can debate how tax positive it's going to be, and you can posit all kinds of scenarios. This one will be tax positive. It's just going to be, because what would not make it tax positive? They're not generating school kids. That's the big problem with development. It's been that way since the 1950s, okay? So this is really a no-brainer when it comes to that. It's just not a close call. Now, as far as the environmental review, I want you to really appreciate that we didn't make this choice. The village board was the one that paved the way for the planning board to function as the lead agency. And the village board and everybody in the community knew that. So you all had an obligation to come to the village board, to the planning board, and provide the information. This is not the appropriate forum to do that. There was months and months and months and months of planning board meetings, and I really would have liked to have heard you there. I really would. But you didn't, and so I'm telling you now, straight up, nothing would have changed had you done it, but you would have had more satisfaction if you did. And I'm telling you that this project is tax positive, because I've just never seen one without school kids, senior housing, and retail that has been anything other than tax positive. Those are the questions I have. Is there more, Stephanie, that you had?
Yes.
Okay, go right ahead.
Thank you for asking. Thank you for all of that. One of the questions that Gessler's letter asked was about enforcement of age restrictions.
Sure.
and how that is actually handled. And also I had a question that stepped off of your reference to the 3-month window for residents of people under 55. So if we're allowing people under the age of 55 to live there, or is it under 18 to live there for 3 months, then how do you really enforce that? And then overall, how do you enforce
There's two ways of enforcing it. One way of enforcing it is the homeowners association, which has liability if it doesn't enforce the restrictive covenants and the declaration that is there, and have liability to its own members. If it exposes themselves to fine or other enforcement, they breach their duties. And then, of course, you have the village's own enforcement. And I will tell you that quite frankly, I'm very old-fashioned when it comes to these things. I believe that the village enforces its laws. And I don't turn around and operate from the assumption that villages are delinquent in their responsibility to enforce their laws. And I don't turn around and fear that when anything is put in, because if you fear that, then you might as well not have any conditions on any development anywhere, because ultimately you're always depending upon village enforcement. So that's what it is.
Okay, so enforcing the age restriction is the responsibility first of the homeowners association?
Not first,
or?
it's a co-responsibility. There's no one first, both have equal responsibility.
All right. So having said that, are there statutory damages for, you said that, the HOA would be liable.
Sure,
but
the HOA could, not statutory damages. If the HOA doesn't fulfill its responsibilities, it can be found to be in violation of its duties to its members. If its members get hit with an assessment because they have not, as the board, enforced the restrictive declaration and the other rules that are applicable to the community, and the village comes in or somebody else comes in and enforces the provisions, and it's found that the board was delinquent in its responsibilities, then yes, they can be liable.
Other questions, and I don't think that everybody was asking questions of, I mean, they were asking questions of the village board, so I just wanted to.
I'm up here to answer any that you want to direct to me.
Yes, and thank you. Aaron Wolf had asked about the difference between a luncheonette and a restaurant, and I don't have the definition of restaurant before me. The copy of the ordinance that everybody has access to here describes this use as coffee shop or luncheonette with counter service and customer seating for a maximum of 15 customers and not exceeding 750 square feet, only permitted if in connection with a mixed-use development. And since this is the only mixed-use development in town, this is the only place this little coffee shop or luncheonette would exist. I don't know what, do you have a copy of the code, Andy, that you pulled out? And so we can, I'm interested in answering the question that somebody had about how it differs from a restaurant.
The existing code?
Yeah. So cute. Thank you. Tim Miller will conjure this device. And while you're looking that up, Tim, another question was that Aaron Wolf asked. He acknowledged the fact that we wouldn't have to hire an additional police officer, but he wondered how much closer this brings us to hiring an additional police officer. And I think it's a reasonable question. I think, Anne, when you spoke to us and provided us with those metrics several weeks ago, I think that it was a quarter, 25% of a police officer. And I don't know how you hire that, but
Well, you can't, but right, he's correct. You know,
Right.
There was this Butterfield, and then another one, and then another one, and then eventually you would need a whole police officer. But
and I don't have your materials in front of me, but I remember that was connected to like demands associated with an increased number of residents. And was it only about the residents, or was it also about the commercial space?
it's both. The ULI multipliers indicate that I believe it's one police officer for, and then something for the per square foot of non-residential space, and that's where that number came from. And I took how much would be needed compared to the cost of the police officer's salary, and entered that into the incremental cost analysis that I had given you.
Aaron, I don't have those, we don't have those numbers in front of us, so we can really provide them to you. And your point is taken, and it does get us closer to a time where we might need an additional police officer. Do you have the definition of restaurant?
It would be, as defined by the dictionary, there's no definitions here covered for a restaurant.
I think it's part of the formula business restrictions law.
Can you speak louder, please?
As part of the formula business restrictions law, I think that we defined restaurant.
It's not in the definition section.
Okay.
The question was about the definition of luncheonette.
Right, I told you what, and you wanted to know.
Public comment is over.
And you were asking about the difference.
right?
Yeah,
There's no definition
yeah.
of luncheonette, and there's no definition of a restaurant in the Cold Spring Code.
Right, the use that we're referring to is more descriptive.
This was a discretionary use that was requested by the planning board that decided to keep it as an option.
So
It's not
so without a
set in stone
definition,
either
it would
way.
be the common definition, customary
But
definitions.
what I'm saying is we recently adopted a formula business restrictions law where I believe that we addressed the question of definition of restaurant. Am I wrong? I'm trying to remember because I don't have it, you know, at my fingertips.
But it was talking about a formula luncheonette.
No. I was asking what the definition of restaurant is. And I'm trying to recall whether or not we wrote a definition of restaurant so that we can distinguish between a formula restaurant or a restaurant.
I can clarify that.
You define formula restaurant.
restaurant is defined.
Okay, would you read that, please?
An establishment where prepared food is sold for consumption on the premises or as takeout. The term restaurant shall include establishments such as a bar or pub or other establishments that sell limited type of food for consumption on the premises or as takeout, such as ice cream shops, donut shops, delicatessens, coffee houses, and similar establishments. But shall not include push charts?
Push
Carts. It's a typo. Wasn't it? And street vendors.
Okay. So if we are wanting to, we've already excluded as prohibited use here restaurants, but coffee shop and luncheonette as described in B12 seems to be a subcategory of restaurant.
You're specifically allowing it though, from the language here. I don't think that would be an issue.
Are you feeling impatient? And I think Joe Patrick asked very specifically if county services are going in, and I feel like that's definitely a question to address to Barbara Scuchamara. Has the county committed appropriated money for that?
Years ago.
What are we not doing?
Public comments over.
We're
Can I-
answering the questions that people ask, the ones that Steve Barton.
Can I entertain a motion to close public and verbal comment on the B4A amendment to Village Code Section 134?
Why, wait, oh, okay.
Second.
Okay, what,
Okay, the motion was,
Close public, verbal, and written comment on B4A rezoning, or B4A local law to amend the Village Code Section 134.
there was a second. Discussion?
well, I'm interested to know, does that mean that we're not gonna answer the questions that people posed to the village board during this meeting?
We're not gonna take any more, because we can't answer the ones that were asked.
And that's what I'm doing. So, what is the concern here?
There's no concern, just going back and forth with the audience and public comments. Close.
We're trying to obtain answers to the questions that were asked.
Problem is the public comment being closed, so we can't, we're not supposed to interact with the public and asking and answering this question.
Can you speak up, please? Can't hear you.
I just said, but the public comment hasn't formally been closed. Formally.
Public hearing has
Right.
And so if the public hearing is open, but we can't take any more, we can't speak, we can't have an exchange with the public?
We should take a vote.
Public, your motion was, again, clarify, please.
We close the verbal and written comment section of B4A local law. I guess is that you close the public hearing as well?
That's different. You're saying you're closed to public comment. Certainly there could be discussion. There's questions to the applicant. But in accordance with the rules, that
Do I need a motion to close public comment then? Or is it just?
it's up to you. Normally you wouldn't, but it's fine.
You made the motion to close public comment.
Okay,
Can you second?
I'm not,
Public comment.
why are we closing the comments?
I'm assuming to,
Public hearing typically is not given to you. Typically, the public comes up and makes comments for the record.
Yes, no, I appreciate
It's not
that.
a discussion back and forth with the public on various
I
issues.
appreciate that, but a lot of the public comment came with questions. People are seeking information, and it's our job to be responsive to the questions that our constituents are asking.
What we're doing is closing the public comment section so that we can address those questions to the developer if there are any left.
But they're not all to the developer,
Okay.
they're questions for us. And we might need additional information from people
so
who have knowledge
let's
here.
handle the public comment. Any other discussion? All those in favor of closing the public comment?
Aye.
Aye. Okay. Now back to you.
No.
So one opposed. So,
But I'm not opposed to someone from the small team or us,
Right,
or even
right.
a legislator that's here to maybe answer a question as a public official. Where we're at with that.
Okay, great. Barbara, has the county appropriated any money to dedicate a senior center
They haven't
to this,
appropriated funds yet, but they have made commitments to bring county services over here and to be involved in the senior center. Yes, they have committed. Over and over again.
Thank you.
Thank you. I think Matt Francisco asked whether or not, and I think Michael Reisman asked this question also, whether or not the village board has a plan in place to pay for costs that may arise as a result of the unexpected costs that may arise out of this development. And to my knowledge, no, the village board doesn't have a plan, except to look to, bond or pay that out of taxes.
Correct.
Anyone else?
I think to some point, when any additional structure or service is taken from our infrastructure, you run that risk. Now, granted, this is a greater risk, but I mean, I think there's, unless the developer is willing to have the developer's agreement that says, and we can prove that his additional has created the infrastructure problem, I don't know that we can have that plan. That's my personal opinion. And again, I mean, I'm not opposed to asking the developer for that. It's, the last, as the statement was made, the last one on, doesn't change the infrastructure.